Welcome to episode 58 on the Law Rapport. Today I'm going to deal with the proposed amendments to the Immigration Ordinance and Regulations. But before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. Now, the first proposed amendment is to amend Section 5.1 of the Ordinance to include some mechanism for the withdrawal of leave to enter the islands. So this section deals with immigration officers granting leave to persons to enter the Turks and Caicos Islands. And the reason why this amendment is proposed, according to the document, is that currently immigration officers are of the view that there is no mechanism to review or alter a decision made with regard to leave to enter, even when it becomes obvious that an error in judgment was made. So if an immigration officer grants a person leave to enter the country and later they realize that this decision was exercised in error, the ordinance, according to the immigration department, doesn't provide them with any mechanism to withdraw leave to enter from the person once leave is already granted. So what this amendment would do is that it would create a mechanism for this decision to be reviewed and the leave that is granted to be withdrawn. Further, on entering the country, there will be an explicit prohibition on visitors to work in the Turks and Caicos Islands. So it appears that immigration or the immigration department is of the view that persons enter the Turks and Caicos Islands on a visitor's visa, for example, are able to gain employment. So this amendment would state clearly that anyone entering as a visitor does not have the right to work. Further amendments as proposed under this section has to deal with the appeal process. So if a person is refused entry into the Turks and Caicos Islands before and they appeal against this decision, then the immigration officers will have to grant them entry nevertheless while the appeal is being heard. This section would change that. The person who is appealing would have to do that appeal from outside the Turks and Caicos Islands. For the proposal to remove section 25 subsection E and F from the ordinance, and the rationale proposed for this is that it would remove all forms of discrimination. This section deals with the revocation of permanent residence work permit, and the ordinance currently states under section 5 subsection E that a person with a mental illness or disorder, their permanent residence certificate could be revoked. And under section 25 subsection F, a person who has a communicable disease that poses the threat to public order, that their permanent residence certificate could be revoked. The proposed amendments will remove these sections, and the rationale is that it will remove forms of discrimination. Section 29 of the ordinance, which deals with application for permits, homeowners and work permits, and which deals with freelance work permit, will be repealed. The specific portion that the amendment seeks to repeal is the freelance work permit. And the rationale for this is that this error is heavily abused and is a key root for fraud. So the Immigration Department appears to be of the view that the freelance work permit program is being used fraudulently, and as a result it is proposed to abolish freelance work permit completely. Then there's a proposed amendment to section 34, which deals with the variation of conditions and duration of work permit. So under the proposal, it appears that a person who applies for a work permit in the unskilled category will be granted a work permit only for 3 years, and in the skill category it will be for 5 years. This does not include self-employed work permits, and according to the proposal, all government stamp holders will be issued permit cards. Section 35, which deals with additional conditions for work permit. The proposal is that the condition for advertisement should be satisfied by electronic means as well. So when a person applies for a work permit, the normal procedure is that this would go in the newspapers, I think 2 or 3 times. And what the proposal seems to be suggesting is that this requirement will also be satisfied through electronic means. And the rationale for this, according to the proposals, is that this will modernize the acceptable media streams. This will increase awareness of jobs availability among Turks and Caicos Islanders. Under section 35 2B, there's a proposal to remove the requirement to include personal address details for non-businesses. According to the proposal, this will be done as a safety measure in light of security risk to persons and property. Section 35, subsection 7b, according to the proposal, will now include a requirement that if a work permit holder is working in, let's say, a business, and that person is up for promotion to a new post, that person will have to go through a full work permit application process in that new position, which means that other people, including Turks and Caicos Islands, have the opportunity to apply for that position. The proposed amendments also covers section 37 of the ordinance, which deals with revocation of permits. And it appears that the proposal is to give immigration the ability to cancel work permit once they are satisfied that the holder is working contrary to the said work permit. So if a person is granted a work permit and then he is employed in some other area, or possibly is working with some other company in that work permit, then the immigration officer or the immigration department will be granted the powers to cancel that work permit, because that will be a violation. Persons will be given 14 days leave with right to appeal, but the appeal will take place outside of the Turks and Caicos Islands, so that person will not be allowed to remain in the Turks and Caicos Islands while the appeal process is progressing. Also, this will include a new section where a work permit holder work permit will be automatically cancelled upon a criminal conviction. Section 38(2), which deals with the revocation of work permit or residence homeowners permit. As it currently stands, if a decision is made to revoke a permit, then the person will have 30 days to make representation why this permit should not be revoked. The proposed amendment will bring forward this time frame to 7 days. Then there is proposed amendment to section 39 of the ordinance, where the proposal, it appears, is to create different categories of temporary work permit. And according to the proposal, these categories are meant to facilitate urgent, critical, and emergency employment needs of a very short-term and temporary nature, as well as those that require a medium-term and transitional capabilities. Section 40 of the ordinance, which deals with business visitors permit. The proposal is to place business visas under immigration control. And according to the rationale for this proposal is that this product was never launched under the labor umbrella. This is meant to facilitate business meetings and those business persons who work in the operations in the islands for a short period throughout the year. Then we now come to what I believe is the most contentious proposal. That is to amend Section 51(2) of the Ordinance. This amendment, as proposed, would require every person in the Turks and Caicos Islands, as I understand it, whether you're a born Turks and Caicos Islander, whether you're a work permit holder, whether you're a PRC holder, whether you have a home owner's certificate, you indigenous Turks and Caicos Islander, you want to call yourself a belonger, doesn't matter. This section will require every person in the Turks and Caicos Islands to carry at all times proof of their status. And in my respectful view, proof of your status cannot be done by a driver's license, an NHIP card, an NIB card. It has to be done either by the presentation of your work permit, your belonger card, your passport, etc. It will also create an offense for not being in possession of the document and the ability of immigration and police officers to detain you. So, and the penalty of arrest and conviction, a person in the Turks and Caicos Islands leaving home without proof of their status could possibly go to jail. The amendment does not set out the penalty, what the fine will be, but it would create an offense. And once it creates an offense, and let me say, this offense will be a strict liability offense. So there is really no defense to this offense. Once you step out of your premises and you're not in possession of documents which will be able to prove your legal status in the Turks and Caicos Island, you would have already committed the offense. This is the most contentious of the proposals in my respectful submission. There's a proposal to amend Section 56 of the Ordinance to include an offense of escaping from custody of the detention center. And the proposal states that currently there is no offense for assisting a detainee to escape from custody. Section 57 will be amended to include the consideration of digital devices as evidence. Section 57 will be amended to include offenses for refusal to be searched and also for any implement found in possession during the period of detention. This has to do with persons detained at the detention center. Section 59 2 will be amended. Currently, Section 59(2) states, where a person enters the islands without leave and the director directs his removal from the island, any money found in his possession shall be used to defray the cost of his removal. This section will be amended to include persons who remain in the islands unlawfully. So, to be clear, if a person is allowed to enter into the Turks and Caicos Islands legally, and then the person overstays and he is arrested and the monies are found in his possession, this money could be used to assist in his removal from the islands. Then there is proposals to amend Section 61 of the Ordinance. And this deals with immigration officers and the general powers of immigration officers. So, this section, according to the rationale, will strengthen the Ordinance because it will include the ability to cause property seized to be auctioned. This will also include a section giving officers the ability to sort a person whom he reasonably suspect to have committed an offense under the immigration ordinance. It will also include a subsection that any devices seized from a person and a scene can be searched, downloaded, and digitally interrogated if they are reasonably believed to contain evidence of an offense under the immigration ordinance. Then there is proposal to amend Section 62, and this is the powers to require information from an employer. And the rationale is that there is currently no time limit, so the amendment will give the employer 5 days to produce the requested information. Then there is proposal to amend Part 7, which deals with the Immigration Appeals Tribunal. And there is a proposal here to change the work permit appeals and appeals from residence permit and homeowners permit to be changed to go to the direction of the minister, such as visas are done currently. So this process will be the same as is currently for visa appeals. So appeal against refusal of residence permit and homeowners permit will be directed to the minister, it appears, and no longer to the Immigration Appeals Tribunal. Then it appears that there is proposal to amend Part 8 of the ordinance, which deals with asylum. However, I see no proposal outlining a pathway to citizenship of persons who are granted asylum. In fact, there is a proposal to amend Section 84, which deals with the grant of asylum. And according to the proposal, the grant of asylum will give leave to remain and work for the initial period of 3 years and provide for an application for indefinite leave to remain in the islands 2 years after the grant, where the person continues to be a refugee. Section 86, appeal for refusal of grant of asylum. The Refugee Review Committee, essentially an appeals panel, will be established to review those applications that were refused, and the process, inclusive of timelines that is to be followed, will be outlined at Section 90, limitations of rights of appeal under Section 86. According to the proposal, it will expand the limitation for right of appeal of refusal that will not be permissible to include failure to meet Section 83(2) above. So let's look at 83(2). The proposed amendment to 83(2) is it will empower the minister to certify that an applicant is ineligible for application against which there can be no appeal. It seems that Section 92(1), which deals with the stop list or prohibited migrants, deportation, and provisions relating to the removal of persons from the islands, will be amended. It is not clear what these amendments are or will be, but the rationale is that it will strengthen the existing policy in law, whatever that means. Section 116(2), which deals with immigration services, will be amended to include that the person offering such services needs to be a Turks and Caicos Islander. The rationale is that in the face of vast illegal migration concerns and prove that some agencies owned by foreign nationals seek to defraud the government at the gain of fellow countrymen. So it appears that currently there are non-Turks and Caicos Islanders who have agencies offering immigration services. This ordinance will amend this section to include that a person offering immigration services needs to be a Turks and Caicos Islander. And there will be an amendment to Part 2 of the immigration regulations, which deals with control of entry into the Turks and Caicos Islands and the duty to report failure of persons to continue journey. This section will increase the fine from 1,000 to 5,000. Then there's the proposal to amend section 13.2, and so the number of years and a work permit and residence permit should be increased to 15 years prior to qualification for an application combined. And what this section currently states is that an applicant who has resided in the islands for a period of not less than 10 consecutive years could apply for permanent residence, or what is currently known as PRC. Now, this will be extended to 15 years. So there will be a 15-year wait before a person is qualified to apply for PRC. There's also changes to, or proposed changes to residence permit by investments. There is proposal to increase the threshold in regard to the amount of money being invested. At section 53.2, which deals with labor clearance, and it appears that this section will not apply to certain positions that Turks and Caicos Islanders are not interested in, such as gardening, housekeeping, domestic yardsman, etc. And so there will be the need to seek labor clearance for these positions. And then there will be a abolishing of the freelance work permit program in its entirety. These amendments, as proposed, are very interesting in my view, including proposals that a person could apply for temporary work permit at an entry at the airport. It is proposed that business visas and temporary emergency work permits will be available for purchase and entry at the airport. These proposals are out for public consultations. I recommend that everyone participate. This is very important. As a matter of law, I have no issues with a lot of the proposed amendments. However, there are some that are objectionable, and I advise persons living in the Turks and Caicos Islands, whether you are a belonger or Turks and Caicos Islander, a work permit holder, a homeowner's permit holder, PRC holder, or whatever your legal status is, that you should participate in the process and let your voice be heard. But more importantly, you should voice your objection against any proposal where every person living in the Turks and Caicos Islands including Turks and Caicos Islanders, will be required to carry with them at all times proof of their legal status. Here is where I will leave it for today. If you like this sort of content, please consider liking, sharing, and commenting. And I will see you very soon in another episode.